First enacted to ensure Southern states respected the rights of newly freed slaves, the 14th Amendment is indispensable to modern civil rights litigation. But what does the amendment say, and how does IJ use it to challenge everything from harassment by police to undue burdens on hair braiders? I'm Kim Norberg of the Institute for Justice, joined by co-host Keith Neely, and we'll be discussing all that and more with IJ attorneys Bob McNamara and John Wrench. This is Beyond the Brief. So Bob, what is the 14th Amendment, and why do we hear so much about it?
So the 14th Amendment is the second of what are called the Reconstruction Amendments, the amendments adopted in the wake of the Civil War. The 13th Amendment, of course, abolished slavery. It made people legally free. And the way I always think of the 14th Amendment is that it was designed to make that freedom meaningful, designed to protect a suite of individual rights from interference by state and local governments. And we hear a lot about it because state and local governments to this day love to interfere with individual rights. And the primary federal protection of those rights flows through the 14th Amendment. And so that's why when you hear about litigation over government power, you're often really talking about the 14th Amendment.
So what are some of those rights?
So the 14th Amendment was designed to essentially do three things. It was adopted in the wake of the Civil War in response to essentially an overwhelming campaign of both government and informal power designed to impoverish newly freed slaves and their white supporters, to keep them essentially in a constant state of penury and terror that was not all that different from slavery itself. So states in the wake of the 13th Amendment adopted laws making it illegal for black people to leave their employers' land after dark, made it illegal for them to engage in certain trades. White people whose businesses offered economic opportunity on an equal basis often found themselves stripped of their property and sometimes banished from the state entirely. And so in response to this widespread campaign of terror, the 14th Amendment is designed to do a few things. It prevents state and local governments from excluding individuals from political society by declaring that they're not citizens. It protects their individual substantive rights through what's called the Privileges or Immunities Clause, and sometimes through the Due Process Clause. And it requires equal protection of the laws. It prevents state and local governments from, for example, stripping people of their property and throwing them out of the state for no reason. And it is all designed to work together to interfere with what was an astonishingly creative campaign by state and local officials to strip people of their basic individual rights. And it's designed to be a robust response to that that's meant to, on a number of metrics, forestall local and state governments from essentially imposing that kind of tyranny.
So this is perhaps a slight detour, but you mentioned privileges or immunities, and there's also a constitutional thing about privileges and immunities. What is the difference between those two things?
Yeah, so the Privileges or Immunities Clause is one of the sections, like Bob said, of the 14th Amendment. And you're right that there is the Privileges and Immunities Clause, which already existed in the Constitution prior to the Reconstruction Amendments. And there is a connection between those things to some degree. And we know that because when the 14th Amendment was designed, we know from the floor sponsor of the 14th Amendment, who is explaining this to people, that they referred to a case called Corfield versus Coryell. And that was a case that was discussing privileges and immunities. And the floor sponsor explained kind of what they were thinking that it would reach, the Privileges or Immunities Clause. And what's important about this opinion is that, and we were kind of referring to this before, of privileges or immunities and sometimes due process. Well, I think this is an argument for why privileges or immunities, is pretty clear, was intended to be the vehicle by which former slaves would be protected now after the Civil War under the Privileges or Immunities Clause when we're talking about their rights. And so the quotes about Corfield are interesting because there the judge is going through a list of things that are privileges and immunities, this part that was already in the Constitution. And the interesting thing that the judge says is that it would be more tedious than difficult to list all of those rights. So those might be things like the right to own property, the right to enter contracts, and the court goes on and on and on to explain these. And so later, when people are thinking about the scope of the privileges or immunities clause, they are thinking of this idea that there is just this list of rights. It's not going to be listed in any particular place, which was also consistent with how they viewed the Bill of Rights in the U.S. Constitution. It wasn't going to be a list of 5, 6, 7, 8, 9, 10 rights. It was kind of all of the rights that come with citizenship. And so the privileges or immunities clause was intended to protect the rights of newly freed slaves in the states against those types of abuses that you were seeing that Bob mentioned under things like the Black Codes.
And one of the things that I think is important to understand when you talk about the 14th Amendment is how the Constitution was understood by the people who adopted it. And so the 14th Amendment is sort of downstream of this longstanding debate we're having in this country about rights. The original Constitution on its face doesn't seem like it requires the states to respect your rights pretty much at all. It mostly speaks to the federal government. But there was this sort of undercurrent of constitutional thought that said, actually, the Constitution and what they started to call the Bill of Rights is a Bill of Rights. And if they're rights, I should be able to assert them against any government. That's what a right is. And they specifically focused on the Privileges and Immunities Clause that you mentioned, Kim, and said, well, actually, the Privileges and Immunities Clause is meant to protect these rights that you have as a citizen of the United States, these substantive individual rights like the Bill of Rights, and that means the states already have to respect them. And the courts said, no, you're incorrect, but a lot of those people ended up being the Reconstruction Republicans, and specifically John Bingham, the floor sponsor in the House, had in previous jobs specifically made this argument that the Article 4 Privileges and Immunities Clause has to protect these substantive rights. And so what he's doing is correcting what he calls in Congress an ellipsis. There are a few words missing in the Constitution that make clear the states have to respect your rights, and this amendment puts those words back in.
I've always heard it kind of described as a second founding in a way, because originally the Constitution, 1787, kind of envisioned this system of citizens but citizens creating states, and then states creating a United States. And then with the Reconstruction amendments, you saw citizens more closely connected with their national government for the first time. And it's a big shift. And just as you saw with the first founding, courts kind of struggling to figure out in the late 18th century, early 19th century, okay, how do we interpret this document? Courts struggled in the beginning to figure out what the scope of the 14th Amendment was. And we had cases like the civil rights cases, Slaughterhouse. Can you talk a little bit about how those early cases where the court was trying to wrestle with and define the 14th Amendment, how those played out and how it kind of influenced the development of the 14th Amendment over time?
But first, explain what even is Slaughterhouse.
That's a fair point. I kind of got ahead of myself. I'm too excited to talk about these cases, but...
Yeah, so there's a lot going on here, but I think kind of the thing to understand is, so what you lay out is, I think, the modern understanding of the evolution of the laws. The original Constitution didn't bind the states, and then there's the second founding, and now the federal Constitution does restrict the states. But an interesting thing is that people who were living through the second founding didn't have the same understanding. They didn't sort of have the history book understanding. A great example, sort of the modern understanding is the Bill of Rights didn't bind the states. But one of the objections in Congress to the 14th Amendment was the Bill of Rights already binds the states. One member of Congress was like, what are we doing? Of course states have to obey the Bill of Rights. And John Bingham has to go, and he gets a copy of a case called Barron v. Baltimore, and he reads it. And the other congressman is like, oh, I had the impression the law was otherwise. I don't know where I got that. And so there is sort of this debate about what the law already is. And it's very clear from the congressional debates that it's meant to change the law. and to impose these substantive protections for individual rights, and specifically to do so through the Privileges or Immunities Clause, which eventually makes its way to the Supreme Court for the first time in the Slaughterhouse cases. And the underlying facts of the Slaughterhouse cases are gross. It's a challenge to a slaughterhouse monopoly, where the rule was if you wanted your cattle slaughtered, if you wanted meat slaughtered, you had to go to the monopolist slaughterhouse. And the justification was public health and safety. Slaughterhouses are gross. They put, awful things and awful in the water, and they don't want that in the water. And you can question whether you need to achieve that public health and safety objective with a monopoly instead of just a rule that says you can't dump animal guts in the water. But they chose a monopoly, and it's challenged on the grounds that this is a restriction on our right to earn a living, in essence. This is exactly the sort of economic exclusion that was at the heart of the Black Codes. This is what the 14th Amendment is aimed at, and you can't just throw me out of business because you like your monopolist buddies better. And the Supreme Court's decision in Slaughterhouse really has to be read in light of those congressional debates where everyone in Congress is saying we are doing something radical. We are changing the fundamental relationship of the states and the federal government and individual rights. And the Supreme Court in Slaughterhouse says, actually, it can't possibly mean that because that would be a radical change. The 14th Amendment can't mean this radical shift in the relationship between individual rights and the federal Constitution. That would be a crazy change. We refuse to read it that way. And the Supreme Court in Slaughterhouse says, it doesn't protect any kind of substantive right to earn a living or really any substantive right at all. But it hastens to add, it does protect, it doesn't mean nothing. Because, you can't read an amendment to mean nothing. So what the Privileges or Immunities Clause protects are what the majority calls rights of national citizenship. So your right to the protection of the federal government on the high seas, your right to access navigable waterways, your right to access federal sub-treasuries, which I always love. Like, nobody thinks the Civil War and the Reconstruction Amendments were about somebody somewhere being turned away from a sub-treasury. But that is what the majority says, and it is, even at the time, it's important to note, pretty instantly recognizably wrong. Like Christopher Tiedemann, a legal scholar at the time, instantly praised the Slaughterhouse decisions, and he praised the Supreme Court for having the courage to defy the will of the people as represented in the text of the amendment. Which is great, right? Like, thank you, Supreme Court, for violating both the letter and the spirit of the 14th Amendment. But it effectively reads the Privileges or Immunities Clause out of the amendment entirely and turns it into a legal nullity.
It's interesting to hear you talk about this as the court kind of actively decided that Congress couldn't have meant what Congress said that it meant, because it seems like kind of the opposite dynamic is happening in a lot of cases that IJ does that involve the 14th Amendment, where basically courts are saying, like, oh, the legislature can kind of do whatever it wants, and we just kind of have to go along with that. And so how does that shift happen? Why are we in I don't care what Congress says land, but then also in deferring to the legislature land?
Yeah, so I think that this is, in one way, it's a feature of the change that the 14th Amendment brings about. And like Bob was saying, it is true that at the time leading up to the 14th Amendment, I mean, you have state courts who are regularly citing federal court decisions about for example, the Fourth Amendment. And even though they might not be saying that they're bound by that, they clearly believe that there are these rights out there. So it's definitely true that there wasn't it wasn't a complete change in how people thought about it. But the 14th Amendment does bring about a change. And so I think one way that you can understand what happens is that the courts are reacting to the fallout of the Civil War and kind of all of the social feelings after that, and the fact that the 14th Amendment is going to change the nature of government. And I think that you can read Slaughterhouse in some ways as just throwing cold water on it. It's pumping the brakes, so however you want to describe it, what it definitely did, I think, as Akhil Amar said, it strangled it in its crib. And so in terms of how we should view that now, I think that there are this kind of pendulum swings between courts doing what they perceive to be slowing down something that is either too hot of a social movement or a big change to the nature of the government, and on the other hand, sometimes just totally deferring to what Congress is doing. And I don't think that there actually is a basic principle that's going on there. I think it does depend on a lot of different factors, like the philosophy that the court at the time is kind of following, what social issues are actually going on. And so I think that all is kind of baked in there. But I don't think that you can look at what the court was doing in Slaughterhouse and now and say that there is just one principle that is operating the same way. I think it's a pendulum that swings back and forth.
Well, and one of the big changes brought about by the 14th Amendment, and Bob, you kind of alluded to this earlier when you talked about Barron versus Baltimore, is this idea of incorporation. And I think to a lot of listeners who aren't lawyers, I think the idea of incorporation, it probably is a concept they haven't heard before. And if they have, it's going to sound a little confusing at first blush. Could you unpack that a little bit? How does incorporation work? What is it? And how did the 14th Amendment ultimately bring it about in the legal community?
Sure. So the basic idea of incorporation is that there is the Bill of Rights, which are the first 10 amendments to the Constitution, and that through the power of the 14th Amendment, that Bill of Rights also applies to the states. And I think that it's a useful shorthand sometime, but I'm not sure it's quite the right way to think about it, and I don't think it's how the framers of the 14th Amendment thought about it. The framers of the 14th Amendment really started from the premise that rights exist. You have rights just in the state of nature, you have rights, and therefore you can assert those rights against the government. And that the rights you can assert certainly include the rights that are listed in the Bill of Rights, but those rights are listed in the Bill of Rights because they exist in the state of nature and the government can't infringe on them. It's not so much that the framers viewed it as taking part of the Constitution and applying it to the states, as that they viewed it as requiring the states to obey these rights that sort of pre-existed the Constitution.
The rights are descriptive, they're not prescriptive.
Exactly.
So when we talk about incorporation, there's IJ had a case about incorporation that we talked about on a previous episode, the Tim's case about excessive fines and whatnot. Why is it that this is still happening? There's still things that aren't incorporated, right?
The law moves slowly and you have to push really hard. But honestly, I think a lot of people and a lot of lawyers who were not steeped in it were surprised by Tim's, that people just assumed that, of course, the excessive fines clause had been incorporated when it had not. And in fact, Tyson Tim's lost in the Indiana courts because the excessive fines clause had not been incorporated, and the Indiana Supreme Court said it didn't have to follow it. So the one thing that kind of I think remains true from kind of looking back through the founding, through the framing of the 14th Amendment through today, is that nothing is ever quite as done as it seems. It's easy to look back 150 years and say, the Bill of Rights didn't apply to the states, and then it did. That's not how people at the time understood it. 100 years from now, it'll be easy to look back and say, in the 21st century, the Bill of Rights was incorporated against the states, but that's not how people living through the moment experience it. And it was, Justice Gorsuch's first question to our opposing counsel in Tim's in the midst of his opening statement was just, okay, come on, counsel, but we can all agree that the excessive fines clause is incorporated, right? Which was the question in the case, and he did not agree. But there was a sense in which it felt like it should be obvious, and we did win the case 9-0, so it turned out to be obvious. But things are only obvious in hindsight. They're only obvious once you go and win the case 9-0.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
The thing that seems weird to me about that process is, how did this never come up before? Surely somebody in the state of Indiana had imposed some sort of excessive penalty on somebody, and surely that person had challenged that in court. How did this not come up until the year, whatever, 2019 or something.
You know, it's something we see in a lot of IJ litigation, which is that it's very hard to get discrete issues to the Supreme Court, in part because there are just a lot of ways to win a lawsuit. And really, the only way the Supreme Court is going to review this discrete question is if you lose on that discrete question, and that makes you lose the case. There are lots of other ways to win a case, and we see this, for example, in our eminent domain work, where we tried for years to get a case to the Supreme Court to overturn its decision in Kelo and just kept winning those cases on other grounds that it is very, you would think, and I thought this as a young lawyer, that just like there have been so many court cases and so many decisions that just everything must have been resolved. And it turns out, no, litigation is complicated, and there are these open questions that hang out for decades on end without anyone ever having exactly the right vehicle to answer them.
And I think that one of the reasons that the law also moves slow there is if you're litigating one of these cases and you have a potential client and you're looking through claims and you don't do public interest litigation, you're going to be assessing the viability of that claim. And let's say it's an amendment that hasn't been incorporated. Well, now if you want to bring that claim, you're actually litigating a lawsuit about incorporating an amendment, which might be
it's a big risk.
Big risk, time consuming, long litigation. It might not settle. There's a lot of things that might change your strategy for litigating it. And so I think that this is another reason that you see these, if you think of different claims as like different tools that are lying around, I think it explains why sometimes when we're looking to do a certain kind of litigation and we find like this is the best tool to be doing this, why is no one doing this? I think there's often things like that where it's risky or it's time consuming or no one has made the argument. I think that is often what's going on. I think that law kind of flows like water through channels, and until someone busts open one of those channels, I think you don't see a lot of litigation there. And so I think that that's a lot of what we do, and the excessive fine stuff is a good example of that. Is if we find a place where a channel should be open, we can focus on doing that in litigation, and then other people will kind of follow.
It is definitely true that saying this is going to take 5 years and we'll have to go to the U.S. Supreme Court is a great thing to say when you're IJ. But if the next sentence is, and you'll have to pay me by the hour the whole way,
right,
like that doesn't land as well.
The client's not quite excited at that point.
Yeah.
You know, John, you talked a little bit earlier about how Slaughterhouse minimized the privileges or immunities clause. We just talked about incorporation, though, and what essentially happened, as I understand it, is after the privileges or immunities clause was kind of foreclosed by Slaughterhouse, and the court started looking for how does the 14th Amendment incorporate these rights against the states, they settled on the due process clause and substantive due process, which some I think view as a bit of a misnomer or kind of like jumbo shrimp, an oxymoron. Process is about procedure. How can you have substantive due process? Could you talk a little bit about how that transition happened?
Yeah. So I actually think that this is connected to this idea that law kind of travels in channels. And I think you can understand what Slaughterhouse did is it closed off one of those channels. You can no longer bring these types of claims litigating about the scope of a privilege or immunity, the clause that was probably supposed to be protecting those rights, and instead you have to find something else. And if the 14th Amendment was supposed to protect those rights, that means that something else in the 14th Amendment is going to be protecting them. And so you start seeing those arguments channeled through the due process clause. And like you said, saying that something is procedural due process versus substantive due process is quite confusing. And
what does that even mean? Because Keith is talking about how substantive due process sounds kind of strange. Procedural due process sounds absolutely insane. And what do those two things even... What is this distinction?
Right. So the thing with calling it procedural due process and why that's kind of strange is due process implies procedure.
Sure.
So it's a bit redundant. It sounds redundant.
It's like ATM machine.
Right. And so when people are talking about procedural due process now, and this is after that distinction is made, procedural due process is have you been given sufficient process by the government to litigate a claim? So that might be you've been given notice and an opportunity for hearing, and that's different from substantive due process, which is where these claims will be channeled instead of privileges or immunities. And what a substantive due process claim is essentially is that no matter how much process you've given me, the government act is still unconstitutional. So there's no amount of process that you could give me to launder the constitutional violation. And so that's a distinction between, an example would just be back to I need a notice and a right to a hearing versus it doesn't matter whether you gave me notice and a right to a hearing, you couldn't do that to me in the first place. And so substantive due process ends up as the vehicle that this litigation about the scope of rights, whether a right has been violated, what's a fundamental right versus a non-fundamental right, all of that ends up in substantive due process.
Though it's worth remembering that the phrase substantive due process is a stupid phrase, but it was coined by the opponents of the doctrine. They gave it a stupid name as a mode of derision. And now in modern times you say, well, it must be a stupid doctrine because it has a stupid name. But no, it's a great rhetorical victory by the enemies of freedom. And I think the thing to remember is the due process clause doesn't actually just say due process. It says due process of law. And since before the American founding, courts have understood that there are certain things that simply aren't a law. You can try to make them a law, but they violate background principles. And the classic one that's commonly invoked in the old cases is that just taking the property of A to give it to B. I could not call that a law. And so certain things were always understood to just be by dint of these background common law principles outside the scope of law. And so they're outside the scope of due process of law. And we call it substantive due process and sort of lose sight of what the Constitution actually says. And I think we lose sight of it because that was deliberately designed by the people who did not like the rule.
So if people want to take your house, the government wants to take your house and give it to a, developer or a corporation or something, that it doesn't matter how much notice they give you, how many forms they give you to fill out, whatever, that the underlying thing they're doing there is still violates substantive due process.
Yes,
that
is the idea, though, as we have experienced here at IJ, that is not always the legal reality.
So due process also exists in a different part of the Constitution. And so why does it have to exist twice?
I mean, it exists twice because the Fifth Amendment, as John Bingham patiently explained to his colleagues in the House of Representatives, only binds the federal government. And so the 14th Amendment binds the states and requires the states to respect individual rights. And it is, sometimes this is a common objection to incorporation, right? That if the 14th Amendment's going to incorporate the Bill of Rights, well, the Bill of Rights has a due process clause. So do the states now have two due process clauses? Everything you believe must be wrong. And I find it kind of a funny objection because it suggests that faced with this overwhelming campaign of terror against individual rights, that the Reconstruction Congress must have meant to be very careful and minimalist in its adoption of rights-protecting amendments, that it couldn't possibly have wanted any overlapping protections, that they would have been very worried about protecting rights too much when it seems very clear they were attempting to protect rights expansively. And so, yes, there may be some overlap among the clauses of the Constitution because the Constitution is designed to protect liberty against very, very creative incursions on that liberty.
All of this seems sort of like a very kind of winding path toward, okay, the 14th Amendment is trying to, protect all of these rights and whatnot. And I understand that you're saying that, the Bill of Rights was understood to mostly apply against the federal government. But even in this place where you're having, these are all incorporated against states, sort of getting there, why do IJ cases about, earning a living or other things that aren't kind of explicitly in any part of the Constitution, why are those happening under this kind of very convoluted process instead of just there's the Ninth Amendment that says the stuff that we didn't list already is still there and still matters the same way? Why aren't all of our cases Ninth Amendment cases?
I mean,
assuming someone has incorporated the Ninth Amendment, which I'm sure has not happened.
That's another thing that has not formally happened. I mean, so there's a certain sense in which all IJ cases could be framed sort of the way we talked about the Reconstruction Republicans thinking of the Constitution. It's just these are rights. I just have a right to do this, and in sort of a state of nature sense, you government have no ability to restrict me because I'm not hurting anybody. The difficulty is that while I think that's correct as a moral principle, what we really see throughout American history is the constant push and pull between power and the inherent temptation to abuse power and the struggle for individual liberty. And I don't think, like, I can talk all day about how terrible and tyrannical state and local governments were in the wake of the Civil War, but that's not like a unique American problem. It's not a unique problem to that moment in history. Power always will be abused. Bullies seek power, and they seek to use power to crush those smaller than they are to their own advancement. And liberty is not sort of the natural state of things. And so what you really see throughout American constitutional history is the push and pull between the gravitational force of the abuse of power and continuing attempts to restrict that power through the force of law. And there is a certain sense, and I think some of the Reconstruction Republicans would have said that really what the 14th, in reality, the 14th Amendment just adds the word seriously to the rest of the Constitution. That's all we're doing, is just we really mean it. And I think there's something to that, but in every generation you have to, you see people using the tools available to them to try to expand whatever little space we have been able to carve out for individual liberty and to try to make that space a little bit bigger.
We spent a lot of time talking so far about due process. There's also another provision in the 14th Amendment that gets a lot of litigation, both here at IJ and elsewhere, the Equal Protection Clause. John, could you talk a little bit about that provision and how it plays into some of our cases?
Yeah, for sure. So this is another interesting example of something that has kind of had a meandering path since the 14th Amendment. There are a lot of scholarship about the original meaning of the Equal Protection Clause, but largely many people think that it was like basically an anti-discrimination principle. And then one of the things that happened to both the Equal Protection Clause and due process is what you see is that certain rights end up getting treated differently under both due process and equal protection, depending on whether these rights are deemed fundamental or not fundamental. And this is its own kind of rabbit hole. But what that means practically for equal protection claims, and this is why you'll hear people use terms like a suspect class when we're talking about equal protection, because if what the government is doing touches on a suspect class, which could be something like race or sex, it will be treated differently because there's a different standard of judicial review that applies. And so a lot of what IJ does is connected with this deeply because many rights have been given short shrift. And so they're subjected to a lower level of scrutiny, whether this is the right to earn a living, free from anti-competitive or monopolistic laws. And what we've been trying to do in our litigation is to make sure that equal protection actually means something. And so what that could look like, for example, in our North Carolina shelters case, that case involved a group who was trying to open up a homeless shelter. It was totally legal to open it there. It checked every box, and the town rejected their ability to open the shelter, citing things like it wasn't harmonious enough with the community, and they speculated that there could be traffic or safety issues. Now, if it really matters whether a court gives that claim actual scrutiny or not. And so I think it's fair to say that before IJ's litigation in this area, a lot of these types of claims were essentially doomed to fail, and many of them did because they didn't touch on one of these suspect classes. And so in that case, what we were able to do was basically force the government to come into court, and they were unable to show that there was any basis in health and safety for excluding the shelter. And what equal protection does there is it requires the government to try to show why it's treating this person who wants to open up the shelter here versus somebody else who's similarly situated And if they're not able to establish that evidence, we were able to succeed on the equal protection claim. And so equal protection in some ways is doing the same thing that a due process claim is doing. And much of our litigation is kind of aimed at the same thing of amping up those rational basis cases.
So at the risk of kind of oversimplifying it, right, procedural due process is I deserve notice in a hearing if you want to do this to me. Substantive due process says I have this right. You can't take that right away from me. And equal protection says, hey, you have to treat me like someone else who's just like me.
Right. Yeah, and all of those, and this kind of goes to what Bob was saying about due process of law. One of the background principles of due process of law was that the government cannot be taking actions that are fundamentally arbitrary, and that meant that the government needs to have reasons for what it's doing. Because if the government doesn't have that, and it's just an act of will, if it's just because I told you so, and the government isn't actually reaching that conclusion for any real reasons, that's not really a law. That's not a law in the way that our system recognizes it. And so in one way, all of those protections are kind of getting at this pushback against arbitrary government action.
Well, in that shelter case you talked about had a lot of facts that kind of show the arbitrariness, right? The zoning code required something like a homeless shelter to be built in a certain type of area that would have necessarily a bunch of traffic. And then to say, oh, but we're concerned that there might be traffic is silly because you're requiring it right there in your code.
John, we've talked a little bit about, the conversations around due process during the designing and ratification of the 14th Amendment. Was there a lot of discussion about the citizenship clause? Was it a contested issue at the time, or was it just, well, this obviously has to be a part of this provision?
Yeah, so this is kind of interesting because any of the debates that were happening had nothing to do with the debates that are currently happening. And so it was really about what is jurisdiction going to reach? And so those were debates about how do we deal with Native American tribes that have treaties with the United States? How are we going to deal with, obviously you don't want someone who's here as an invading army, so like that's an exception. How do you deal with people who are here as diplomats and have children? It was really things like that. And the Supreme Court in the late 1800s, they address whether someone who is here permanently as a legal resident, whether their child counts it as a citizen, or whether they could restrict them from coming back in the country. And the court says, yes, this person is a citizen. So any of the debates that were raised, they don't really answer this question in an explicit way, though. I think that one thing, and again, as a spectator, because like Bob said, we don't litigate this issue. As a spectator, I think that one thing I'm seeing that does kind of make me think of the types of things we see in our litigation in general is that when there is an issue that people have very strong feelings about, that can either go this way of wanting courts to defer and to let the executive or state or local governments to do what they want to do, or you want the court to interfere to prevent the executive or state or local governments from doing what they're doing. And I think that the one thing with this and the fact that it's also being done through an executive order is just for people to kind of keep in mind that whatever powers you give the government to do at your behest or things that you support are going to eventually be used in ways that you probably disagree with. And so I think that that's just a good thing for people to keep in mind as this debate goes forward, and as people are kind of commenting on courts deciding the issue. Yeah, I think that is a good thing for people to keep in mind.
And I do think sort of the overall shape of the debate about the 14th Amendment does seem to consistently take the same form, which is if you look at the debates in the Congressional Globe, the discussion among the people who are drafting it is, well, surely it doesn't reach this. Surely it's not so expansive as to protect all of these individual rights. And the people writing it say, well, yes, it is. And they say, surely this isn't expansive enough to reach the Chinese on the West Coast. And the people framing it say, well, yes, it is. Of course it's that expansive. And then when it gets out of that context, the the response is always, well, surely it can't mean this. Surely it can't be that expansive. But the reality is the 14th Amendment was written as a radical and expansive change to the Constitution, and that means it has radical and expansive consequences. And that is the intended result by the people who framed and ratified the 14th Amendment, was that it was a massive shift in individual rights in this country.
So just to sort of, wrap up, what does the future look like for the 14th Amendment? You've talked about how it's, intended as this radical sweeping thing, and then how kind of almost immediately courts were cabining it, making it smaller, making it mean less and less. So what direction does this head in now?
I mean, we're going to do our best. So I think the error people sometimes make in thinking about the Constitution is that they think about it purely in sort of the originalist historical context of what it means in the abstract. But in reality, the Constitution is, and debates about the Constitution are a means by which we carry on the conversation that we've been having in this country since its founding, which is, what is the government's relationship going to be with the people and with me as an individual human who has rights? And that debate is never over, right? That is an ongoing fight between the forces of liberty, such as we are, and the inevitable aggrandizement of those in power. And I think ultimately how that fight turns out depends on how good a job we do of fighting it. But it's not a question that's settled. It's not something that we can put away and leave for another day. It's something that actually every generation has to have that debate and fight about. And in every generation, it has to be won by people who believe in individual liberty. And it is not the legacy we can leave our children is not, in fact, individual freedom. The legacy we can leave our children is just the opportunity to continue fighting for individual freedom.
Thanks for coming in and talking with us, guys.
Thanks for having us.
Thanks for having us.
Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.